Hello, my name is Dr. K.P. Asha Mukundan and I am a faculty with Tata Institute of Social Sciences, School of Social Work, Center for Criminology and Justice. Today I am going to talk about the module on commonality and differences in criminal justice system and juvenile justice system, which is the module under the subject criminology and the paper of juvenile justice. Some of the objectives of this course is to understand and appreciate the need for a separate juvenile justice system. It is also to understand the differences between the criminal justice system and the juvenile justice system. The third objective of this module is to be able to understand the principle behind the working of the juvenile justice system. To begin with, let us get down to understanding what is a criminal justice system. The criminal justice system is a system of practices and institutions of government directed at upholding societal control, deterring and mitigating crime, or sanctioning those who violate laws with criminal penalties and rehabilitation efforts. Criminal justice system upholds the principle of justice and rights both for victims and offenders. Coming to the juvenile justice system, which is a part of the larger criminal justice system, and it stems from the understanding that children committing offences require a differential treatment as compared to the way adults are processed in the system. We shall be calling criminal justice system as CJS. Just like the CJS upholds the principle of justice of rights both for victims and offenders, similarly does the juvenile justice system, which we shall be calling the JJS. The JJ Act takes active responsibility in looking into the welfare of child victims of abuse and neglect by creating avenues for care, protection and rehabilitation of such children. The Act incorporates the principle of best interest of the child and follows the paradigms of child development. It has brought about a great change in the way the law treats children. The first separate court for children or juveniles as it was known was established in the US in 1899. The court's principles, the key principle espoused the following 4 ideas. 1. Children have differential needs than adults and need adult protection and guidance. 2. Children have constitutional human rights and need adult involvement to ensure these rights. 3. Almost all children can be rehabilitated. And 4. Children are everyone's responsibility. In India, the first children's court was set up in between 1920 and 24 with the enactment of the Madras Children's Act of 1920, followed by the Bengal Children's Act of 1922 and the Bombay Children's Act of 1924. There is no clear documentation though on when exactly was the first children's court in India set up. However, the children's court set up in the earlier years looked after both children in need of care and protection as well as children in conflict with law. It was post 1960 with the Children's Act coming to force was 2 different machineries set up to look and address the issues of the 2 categories of children. The 4 principles which we just mentioned above justifies the need to set up a separate system for children. Besides this, in India, the other need to set up a separate different system from adults was also because of the categories or the differences which are mentioned below. First, the philosophical assumption between the 2 systems are very different. Criminal justice system follows the principle of penology, where criminals are given punishment for the offences that are done by them. However, juvenile justice system follows the principle of corrections, where juveniles are given orders for rehabilitation and reintegration. Difference in philosophy assumptions gives rise to the difference in the way procedures are followed, and not only followed, but we are also talking about implemented. There is also different uses of terminology which through many a times would have the same meaning and conduct of that in the adult system, but is said differently to diminish the negativity with which the process is being seen. These are discussed further in the chapter which we are going to talk about now. As mentioned earlier, the juvenile justice system is an offshoot of the criminal justice system, and so all the systems that function in the juvenile justice system are borrowed from the larger criminal justice system. Hence, in order to under the juvenile justice system and how it is different from the criminal justice system, one needs to understand the working of the criminal justice system. Let us understand the juvenile justice system, which is the larger system under the criminal justice system, or the smaller system within the criminal justice system. The criminal justice system has four important proponents in India, namely the investigation agency, who is the police, the judiciary, the prosecution wing, and the prison and correctional services. Let us first talk of the investigation agency, which is the police. The basic duty of the police force is to register cases, investigate them as per the procedures laid down in the Code of Criminal Procedure, we would be calling it as CRPC, and to send them up for trial. The role of the police is not only to deal with offenders, but also to protect the victims. The role is true for that of the adults as well as juveniles or children. The difference in functioning and terminology are as given. I shall now speak about some of the differences in functioning as well as the terminology while working with the police. The role of the police in an adult system is to arrest an adult. The role of the police in the juvenile justice system is to apprehend. The word arrest is not used. In an adult system, the police can release the adult on bail. In the JJ system, the police can release the child in conflict with law. Also, now from here on, I shall call the person as CCL on bail only if the guardian signs the bail form. An adult has to be produced before the magistrate within 24 hours, and so does the child have to be produced before the magistrate within 24 hours. The police can produce the accused in the uniform in an adult system. However, in a juvenile justice system, the police has to produce the CCL before the magistrate or the juvenile justice board in civil dress. In the adult system, use of handcuffs is allowed, whereas in a JJ system, use of handcuffs is not allowed. At the time of first production, the police submits remand documents which either ask for police or judicial remand, whereas in a JJ system, the concept of remand does not apply. The CCL is either admitted in the observation home or released out on bail. In the adult system, the adult can be kept in a police lockup, whereas in a JJ system, the CCL cannot be kept in a police lockup. In the adult system, the police can ask for police custody for questioning, whereas in a JJ system, the concept of police custody does not exist. In the adult system, the police has to submit the charge sheet within 60 days or 90 days in case of non-bailable offence, failing which the accused can seek bail. However, there is no concept of bailable or non-bailable offence in the JJ system, and so the final report or the charge sheet is called the final report, has to be submitted at the earliest. So, these are some of the differences in the adult system and the JJ system with respect to the police. The JJ Act calls for the creation of child welfare police officers and special juvenile police units to deal with children in conflict with law or CCIs and children in need of care and protection or CNCP. Every police station must have at least one police officer designated and specifically trained as the juvenile or child welfare officer. The Act requires that every child apprehended by the police be placed under the charge of the Special Juvenile Police Unit or the designated police officer, who shall immediately report the matter to the member of the board. The officer in charge of the police station must inform the child's parents or guardians and the probation officer of the arrest. If the child is not released from the police station on bail, he must be kept in an observation home pending appearance before the board. The role of the police also extends to children in need of care and protection. They are mandated to conduct rescue operations to rescue children who are trapped in situations like child labor, prostitution, abuse, etc. The role of the police in such cases is to produce the child before the Child Welfare Committee or the CWC. The next agency is the judiciary or the courts. The cases constituted by the state, police and the Central Investigation Agency are adjudicated by the courts. We have a 4-tier structure of courts in India. At the bottom level is the Court of Judicial Magistrates. It is competent to try offences punishable with imprisonment of 3 years or less. Above it is the Court of Chief Judicial Magistrates, which tries offences punishable with less than 7 years. At the district level, there is a Court of District and Sessions Judge, which tries offences punishable with imprisonment of more than 7 years. In fact, the code specifically, that is the CRPC, specifically enumerates offences which are exclusively triable by the Court of Sessions. The highest court in the state is the High Court. It is an appellate court and hears appeals against the orders of conviction or acquittal passed by the lower courts. Apart from having writ jurisdiction, it is also a court of record. The law laid down by the High Court is binding on all the courts subordinate to it in a state. Right at the apex, there is the Supreme Court of India. It's the highest court in the country. All appeals against the orders of the High Court in criminal, civil and other matters come to the Supreme Court. This court, however, is selective in its approach in taking up cases. The law laid down by the Supreme Court is binding on all the courts in the country. However, this system functions differently under the Juvenile Justice Act, which calls for the creation of 2 distinct bodies to make orders related to children. The Juvenile Justice Board, better known as the JJB, comprised of a magistrate and 2 social workers to hear and determine cases of children who have committed or alleged to have committed offence. JJB looks at cases of children who come in contact with the criminal justice system, that is, children who have allegedly committed offence. These children are known as children in conflict with law or CCL. The JJB has to function from the premise of the observation home and not in the premise of the regular court. This is to ensure that there is a separation in the way the juveniles are processed from the adults. Talking about the Child Welfare Committee, it comprises of 5 social workers to hear cases of children in need of care and protection. The 2 social workers who are appointed on the JJB and the 5 social workers who have been appointed on the CWC while functioning on the bench would have the powers of the Metropolitan Magistrate. Unlike the 3-tier system in the adult criminal justice system, the cases of conflict with law would be dealt by the JJB irrespective of whether they are offences triable under 3 years, 7 years or above. Courts sentenced adults to prison or release them on probation if found to have committed a crime. Post imprisonment, the offender is entitled to avail of probation given the conditions and eligibility criteria stated in the prison manual. However, JJBs have many options before them with the premise mentioned in the preamble of the JJ Act that institutionalizing a child should be the last resort. They are not subject to imprisonment, but final orders can be passed with respect to what I am going to now narrate. 1. Allow the juvenile to go home after advice or admonition following appropriate inquiry and counseling to the parent or the guardian and the juvenile. The second option is to direct the juvenile to participate in group counseling and similar activities. The third option before the JJB is to order the juvenile to perform community service. The fourth option is to order the parent of the juvenile or the juvenile himself to pay a fine if he or she is over 14 years of age and earns an income. Fifth, direct the juvenile to be released on probation of good conduct and placed under the care of any parent, guardian or any other person called fit person for up to a maximum of 3 years. Sixth, direct the juvenile to be released on probation of good conduct and placed under the care of any fit institution for up to again a maximum of 3 years. Direct the juvenile to be sent to a special home until he or she turns 18, or in the case of a juvenile who is over 17 years for a period of not less than 3 years. In an adult system, emphasis is laid on the nature of offence committed, although it is seen in the context of which it was committed. There is no concept of parole in the JJ system. Similarly, in the JJ system, emphasis is laid on the circumstances in which the offence was committed, and the offence is also seen within that context. This is why the JJB has to mandatorily call for a social investigation report, which is called an SIR, from a probation officer or a social worker, which is a practice which is not followed in the adult criminal justice system. Just like one of the job responsibility of the judiciary is to make jail visits, the JJB is also mandated to visit special homes and the observation homes. The third is the prosecution wing in the whole list. It is the duty of the state to prosecute cases in the court of law. The state governments have constituted cadres of public prosecutors to prosecute cases at various levels in subordinate courts and the High Court. This system functions differently in different states in the juvenile justice system, as there is no much clarity on the working here. There are many juvenile justice boards which function with or without a prosecutor. The ideological clash with this post is that when it is the role of the state to protect the child who is the ward of the state, if it is the state that provides for a prosecutor to prosecute the child. This makes it difficult for the child who is left with no choice to then appoint a lawyer to defend his case. This should also be seen in the light of weak free legal service system in the country. The last, the prisons and the correctional services. This is the fourth important arm in the criminal justice system, which is called the prisons. Convicted adults are put into the prison, which are under the control of the state government. In India, there are no prisons run by private organizations. Those given orders of being placed under the custody in the JJ system are placed, however, in a special home which is supposed to be a correctional home. In the JJ system, the special home is supposed to have facilities for counseling, education, vocational training. The special home has to prepare a care plan to chalk out the rehabilitation strategy for the juvenile, which would help him or her become a productive citizen in the society. The special home may be a government run or run by private organizations or NGOs, unlike the adult system where the prisons are not run by private organization. Let's look at some of the other differences between the criminal justice system and the juvenile justice system. One is the issue of confidentiality. The Act lays down the principle of right to privacy and confidentiality in the JJ system. This means that the identity of the child cannot be revealed under any circumstances to ensure his or her protection, and this provision facilitates the process thereby. And the child would be able to make a future once he goes back into the society. Thus, all reports of the probation officer, social workers are confidential. No media, be it the print or electronic media, can print any item in a manner which discloses the identity of the juvenile, for example, name, address, name of the school, etc. Pictures of the CCL cannot be printed. However, the JJB or the CWC can allow the printing of such information if it is in the opinion that such disclosure is in the best interest of the child. The Act makes disclosure of identity as a punitive offence. Criminal justice system does not have such mandatory principles of confidentiality. All the court proceedings are open to public and the criminal records are accessible to people for publication. The next we shall be talking about bailable and non-bailable offences. The adult criminal justice system under the CRPC have defined bailable and non-bailable offences. Those charged with non-bailable offence are considered to be serious offence, and hence to protect the community from the individual who may indulge in further harm or tamper with the evidence or intimidate victims, the bail is denied to the adult. Bailable or non-bailable depends on the nature of offence committed. However, in criminal justice system, bailable offence also, the grant of bail is a matter of judicial discretion. In the juvenile justice system, irrespective of whether the offence under CRPC is bailable or non-bailable, the CCL is eligible for bail. In other words, the presumption is in favour of bail. However, the grounds for refusal are broad and include situations where there appears to be reasonable grounds for believing that release is likely to bring the CCL into association with any known criminal or expose him to moral, physical or psychological danger, or that his release would defeat the ends of justice. Bail in the JJ system is denied not because of the nature of offence, but keeping in mind the situation in which the CCL resides, and the CCL could be at risk if sent to the community. Similarly, now let us look at the role of a probation officer in the JJ system and the criminal justice system. Now we shall look at the role of a probation officer in the criminal justice system and the juvenile justice system. The role of a probation officer in a criminal justice system is limited with respect to those who are found guilty and given probation order, whereas in a juvenile justice system, the role of probation is applicable not only to the children in need of care and protection, but also those in conflict with law. The role of probation officer in a criminal justice system begins at the end of the trial, whereas the role of the probation officer begins right at the time when the child first enters the juvenile justice system. The role of probation officer in the criminal justice system is only when there is a probation order, whereas the role of a probation officer in a juvenile justice system begins when the child first enters the system, and it is not limited to only probation orders. There is no provision for offenders to be kept under the supervision of a probation officer while on bail in the criminal justice system. However, Section 12 of the Juvenile Justice Act mandates that the child in conflict with law may be kept under the supervision of a probation officer at the time of bail. In the criminal justice system, all those given the benefit of probation under the criminal justice system will not suffer disqualification, whereas all those found to have committed an offence and dealt with the provisions of the JJ Act will not suffer disqualification except those dealt under section 19(1) of the JJ Act. In the criminal justice system, adult can be placed for probation only with a government appointed probation officer. However, in a juvenile justice system, the CCL can be placed on probation under the care of a probation officer, parent, guardian, fit person or a fit facility. Now let us look into the aspect of social investigation report, better known as SIR. Social investigation report is one of the unique aspects of the juvenile justice system which is lacking in the criminal justice system. As per the JJ Act, during the course of the case, the JJB will or can order the PO to find out about the character and social background of the child in conflict with law. The PO will speak to the child in conflict with law and the child in conflicts with law's parents and guardians if any. If the PO can take the opinion of the professionals or experts, the PO will then present a report which is called the social investigation report. This is submitted to the JJB. The report of the PO about the child is confidential and only the JJB can read it. The JJB may also call for the report of professional experts or ask the parents to provide documents like birth certificate, school leaving certificate, etc. In some cases, instead of the PO, the JJB may assign a voluntary organization to the child to carry out the tasks of the PO. However, in the adult criminal justice system, reports of only the police are accepted and the concept of social investigation report does not exist. Next, let us look at the role of social workers and NGOs. Recognition of social service organizations under the Act is one of the uniqueness of the JJ system. JJB includes 2 social workers, out of which one is a woman. Voluntary organizations' role establish and maintain child care homes after obtaining recognition from state governments. The social worker or voluntary organizations are appointed as part of fit person or fit institution. Representatives of voluntary organizations, social workers are appointed on inspection committees and to conduct social audits of children's home. Social workers representatives of voluntary organizations are also appointed on central and state advisory boards. There is no formal role of NGOs however in the criminal justice system, though there have been a recent development where NGOs are being permitted to enter prisons to provide social assistance to under trial prisoners. Next, let us look at the terminologies which are different between the criminal justice system and the juvenile justice system. The criminal justice system, the terminology used is criminal, convict and crime. However, in the juvenile justice system, the terminology used is children in conflict with law, or crime is called an offence. In the CJS, the people who commit an offence or alleged to have committed an offence are called accused or under trials, whereas in the JJ system they are called alleged to have committed an CCLs alleged to have committed an offence. In the criminal justice system, the word used is arrested, whereas in the juvenile justice system, the word used is apprehended. In the criminal justice system, the person is taken to a court, whereas in the juvenile justice system, the person is taken to a juvenile justice board. In a criminal justice system, a person post conviction is sent to a prison, whereas in a juvenile justice system, post the final order, the person is sent to a special home. A person whose trial is going on is called an under trial prisoner, and the person is kept in a prison, whereas in a juvenile justice system, the concept of under trial does not exist. They are sent to an observation home. In criminal justice system, the police submits a charge sheet, whereas the charge sheet is called a final report in a juvenile justice system. In a criminal justice system, the process is called punishment, sentence and conviction, whereas in a juvenile justice system, it is called the final order. In the criminal justice system, there is a concept called remand report, whereas in a juvenile justice system, this remand report does not exist. It is called the production report. Concluding this module, the juvenile justice system is a part of the larger criminal justice system. All the agencies working with the JJ system are drawn from the agencies that work under the CJS system, like the police and the judiciary. However, the JJ system is implemented by the Ministry of Women and Child Development. Unlike the principle of punishment followed by the criminal justice system, JJS follows the principle of rehabilitation and reintegration. Juvenile justice system draws heavily on the NGOs for the purpose of rehabilitation. On principle though, the CRPC exists for the procedures, it is followed differently in the JJ system. The JJ system believes in institutionalizing the individual as a matter of last resort, and so emphasizes a lot on non-institutional services like probation, community service, group counseling. Like the criminal justice system, the JJ system also works towards protecting the victims and the rehabilitating the offenders. The CJS is a well-established system working for the past 100 years. The JJ system, though functioning since 1920, is still struggling in the working because individuals prominently working with the philosophy of punishment is drawn to work in the JJ system, and it becomes difficult for the officials to make that attitudinal or philosophical shift while working. So, there is still a long way to go and get the systems in place in the juvenile justice system. There is still a lot of information about the working of the juvenile justice system in the international context available online. Not much of information about the Indian context is available. There are very few researches as compared to the international systems in the Indian context. For more details and information, you are requested to look into the references that are provided along with this module. There is more information about the international context online rather than the national context, as the research studies in the Indian context are not as much as that available in the international context. However, still there is plenty of information available online. Do look at it for further references. Thank you.